Everyone. Welcome to Crispy Info. Today we will discuss a very important chapter of Lakshmikant, that is the preamble of the Constitution. So, the American Constitution was the first to begin with a preamble. Many countries, including India, followed this practice. The term preamble refers to the introduction or preface to the Constitution, and it contains the summary or essence of the Constitution. Summary or essence of the Constitution. N. A. Palkhiwala, an eminent jurist and constitutional expert, called the preamble as the identity card of the Constitution. Preamble as the identity card of the Constitution by N. A. Palkhiwala. Moving forward, the preamble to the Indian Constitution is based on the Objectives Resolution drafted and moved by Pandit Nehru and adopted by the Constituent Assembly. It has been amended by the 42nd Constitutional Amendment Act 1976, which added the three new words socialist, secular, and integrity. So these three new words was added by 42nd Constitutional Amendment in 1976. We will see the exact text of the preamble. So the people of India have the rights. So preamble provides all the power to the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens. So these things that have been mentioned in preamble, like sovereign, socialist, secular, democratic republic, it demonstrate the nature of Indian Constitution, like the pillars on which the Indian Constitution is based on. So justice, three type of justice we will talk: social, economic, and political. Liberty of thought, expression, belief, faith, and worship. Equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. So in our Constituent Assembly, this 26th day of November 1949, that is 26th November 1949, hereby adopt, enact, and give to ourselves this Constitution. So the preamble, when we talk about preamble, it was adopted and enacted on 26th November 1949. However, the original Indian Constitution came into effect on 26th January 1950, but this preamble was adopted, enacted, and came into effect from 26th November 1949. Now we will see some ingredients of the preamble. Ingredients of the preamble. So the preamble reveals four ingredients or components. First, source of authority of the Constitution. So the basic source, the content of the Constitution comes from preamble. The preamble states that the Constitution derives its authority from the people of India. So people of India ultimately have the power, the full right, or we can say that the power that we derive in the preamble is from the people of India itself. Then we will see the nature of Indian state. So it declares that India to be of a sovereign, socialist, secular, democratic, and republican polity. We will see in detail what is the meaning of these terms like sovereign, socialist, secular, etc. So third one is the objectives of the constitution. What is the objective of the constitution? So it specifies the justice, liberty, equality, fraternity as the objective. So the main objective of the preamble is to promote the concept of justice, liberty, equality, fraternity. The date of adoption is mentioned in the preamble, as we have already discussed about it, 26 November 1949 as the date. So we will discuss some of the key words like sovereign, socialist, secular, democratic, republic, justice, liberty, equality, fraternity. So starting from the sovereign, what is the meaning of sovereign? The word sovereign implies that India is neither a dependency nor a dominion of any other nation. So we are independent, right? So but an independent state, India is an independent state. No other country can enforce their law. They cannot shape our geopolitical affairs, or they cannot meddle into our political, social, or cultural activity. So there is no authority above it, and it is free to conduct its own affairs, both internal as external. So if India wants to manage its internal affair, India is free to do their own, and also the external politics, like the foreign affairs that we maintain, India is free to do so according to its own way. So though in 1949, India declared the continuation of her full membership of the Commonwealth of Nations and accepted the British Crown as the head of the Commonwealth, this extra constitutional declaration does not affect India's sovereignty in any manner. So when India became free, in 1949, actually we agreed to accept the membership of Commonwealth of Nations, but it doesn't mean that this will affect India's sovereignty, because British Crown is the head of the Commonwealth. However, we agreed to the terms and situation that okay, we will be the part of the Commonwealth, but it doesn't mean that India is not a sovereign country because of this. So further, India's membership of the United Nations organization UNO also in no way constitutes a limitation on her sovereignty. So the question arises here, like, if India is a part of the United Nations, does that mean that India is not a sovereign country because the United Nations will determines the foreign policy, or United Nations will uh, directly or indirectly course the future course of action of India? So no, it is not like that. So being a sovereign state, India can either acquire a foreign territory or cede a part of its territory in favor of a foreign state. So this is the meaning of sovereignty. Sovereignty means independent or not dependent on any other country or any other nation, particularly in the context of India and constitution. Next we will see socialist. What is the concept of socialist? So even before the term was added by the 42nd Amendment in 1976, the constitution had a socialist content in the form of certain directive principles of state policy. So this word, like socialist, was inserted by 42nd Amendment in 1976. But before that, even uh, like India followed socialist principle. In other words, what was hitherto implicit in the constitution has now been made explicit. So what that was hidden, that was not clear in the constitution earlier, became clear in 1976 through the addition of this word socialist in the preamble, and now it has been made explicit, that is clear, that can be seen. Moreover, the Congress party itself adopted a resolution to establish a socialist pattern of society in its Awadi session as early as in 1955 and took the measures accordingly. So, socialist principle is in the fabric of our constitution. Notably, the Indian brand of socialism is a democratic socialism and not a communist socialism. So, there are actually two kind of socialism. What is democratic socialism and what is communist socialism, we will see further. So India follows democratic socialism. In communist socialism, China follows it, Russia follows it. So, which involves the nationalization of all means of production and distribution and abolition of private property. So, whenever we talk about the democratic socialism, it means that all the production to be nationalized, like the nation has its control over the production of all the goods, and there is abolition of private property. So democratic socialism on the other hand holds faith in a mixed economy. So this is called the communist socialism that the China follows. There is no private property, no capitalism, and all the production, the means of production is nationalized. Wherever in democratic socialism that India follows is like mixed economy. Mixed economy means coexistence of private and public property. All right. So says, as the Supreme Court says, democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity. Indian socialism is a blend of Marxism and Gandhism, leaning heavily towards the Gandhian socialism. So, Marxism talks about a socialism in which there is no capitalist state, or there is no control by the capitalist people. There is no existence of private property. Gandhism socialism talks about cooperative societies, like existence of cooperative society. So it is a blend. Indian socialism is a blend of Marxism and Gandhism both, but it is basically tilted towards Gandhian socialism. All right. So the new economic policy in 1991, we had economic reforms in 1991 of liberalization, privatization, globalization, has however diluted the socialist credential of the Indian state because it threw the Indian market throughout the world. Like globalization came into existence. And in globalization, what happens? One country, the trade of one country will come to another country without any barrier, like free trade concept is there in here, globalization. So somehow it diluted the socialist credential of the Indian state. But originally, India is a democratic socialist country. We will see new concept secular, because the word secular was also added by 42nd Constitutional Amendment 1976. So, however, as the Supreme Court said in 1974, although the words secular state were not expressly mentioned in the Constitution, there can be no doubt that constitution makers wanted to establish such a state, and accordingly Article 25-28, which guarantee the right to freedom of religion, have been included in the Constitution. So originally when Constitution came into existence, there was no word like secular, but the word secular is an old concept in Indian context, because in Article 25 to 28 we talk about the freedom of religion. So the Indian Constitution embodies the positive concept of secularism, that is, all the religions in our country, irrespective of their strength, have the same status and support from the state. Because when we talk about the Western concept of secularism, it's all about like religion is separated from the state, but the Indian secularism is totally different. Indian secularism talks about the coexistence of each and every religion and equal treatment to all the religion, and the equal status and support from the state. So we cannot separate religion from the state, because India is a multi-religious, multi-diverse culture. So definitely, but we can treat all religion as equal. We can provide equal status to all religion, and this is the concept of Indian secularism. All right. Now we will see the democratic. What does the word democratic signifies? So, a democratic polity, as stipulated in the preamble, is based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. So, possession of supreme power by the people is the actual meaning of democratic term democratic. So, democracy is of two types: direct and indirect. In direct democracy, the people exercise their supreme power directly, as in the case of Switzerland. There are four devices of direct democracy, namely referendum, initiative, recall, and plebiscite. So, whenever there is direct democracy, people have the ultimate right. They directly participate in the politics and the constitution of the country to frame the law. Like in Switzerland, people directly takes part in the referendum. So basically, there are four components of direct democracy: referendum, initiative, recall, and plebiscite. And in indirect democracy, on the other hand, the representative elected by the people exercise the supreme power and thus carry on the government and make the law. So we also call this type of democracy as a representative democracy that India follows. Okay. So in direct, people directly takes part through referendum, like people are there, people. And in indirect, it is through the representative government, a representative government. And also in representative democracy, there are two type of government, that is parliamentary and presidential. And India follows the parliamentary government. Presidential is followed by the US. All right. So Indian constitution provides for the representative parliamentary democracy, under which the executive is responsible to the legislature for all its policies and actions. So Indian constitution follows indirect democracy, and even in this indirect democracy, India follows the concept of parliamentary democracy. Okay. So universal adult franchise, periodic elections, rule of law, independence of judiciary, and absence of discrimination on certain grounds are the manifestations of the democratic character of the Indian polity. So, whenever we talk about the characteristic of Indian polity, so these are the people above 18 plus, they have the right to vote. Periodic elections are the essential feature of democracy. Rule of law is there. Independence of judiciary can act impartially without any discrimination. So judiciary is independent. There is no control of judiciary. An absence of discrimination. There is no discrimination socially on any ground. So these are the essential feature of the Indian polity. So the term democratic is used in preamble in the broader sense, embracing not only the political democracy but also the social and economic democracy. So whenever we talk about the word democracy in the preamble, there are three types of democracy. One is political, the second is social, and the third is economic democracy. So this dimension was stressed by Dr. Ambedkar in his concluding speech in the Constituent Assembly on 25th November 1949 in the following way. So what our Dr. Ambedkar had said on 25th November 1949, we will see. So he said, political democracy cannot last unless there lies at the base of its social democracy. So there is a great need of social democracy. Until and unless social democracy exists, there cannot be a concept of political democracy. So what does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity. That's the concept of social democracy. And the principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity, in the sense that to divorce one from the another is to defeat the very purpose of democracy. So we cannot separate this term like liberty, equality, and fraternity. And whenever there is a separation, it means that the very purpose of democracy is dead. So liberty cannot be divorced from equality, equality cannot be divorced from liberty, nor can liberty and equality be divorced from the fraternity. And without equality, liberty would produce the supremacy of a few over the many, and equality without liberty would kill the individual initiative. So this is how B.R. Ambedkar has defined the very concept of social democracy. Fabric of social democracy, that is liberty, equality, and fraternity, cannot be separated from each other. Now, in the same context, Supreme Court has observed in 1997 that the Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic, and political justice in a social and economic democracy of the Bharat Republic. So, the Constitution has provided to establish an egalitarian social order, a social order that is based on the concept of equality, on justice, liberty. So every citizen looks for social, economic, and political justice in a social and economic democracy, and that's the fabric of, that's the main constituents of Bharat Republic. Now we will see a term that is called republic. So we call India Republic of India. So why India is a republic? So basically we will see, like, there are two categories. A democratic polity can be classified into two categories, that is monarchy and republic. In monarchy, the head of the state, usually king or queen, enjoys a hereditary position, that is, he comes into office through succession, birth after birth after birth, like in Britain. But in a republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period, like US. In the US, elections are usually conducted after every 4 years, and the head of the state is always elected directly. So therefore, the term republic in our preamble indicates that India has an elected head called the president, and he is elected indirectly for a period of 5 years. In the US, we had seen for the period of 4 years a person is elected directly, but in India there is an indirect election for the post of president, and the president is usually appointed for a fixed period of 5 years, and this is the word republic signifies. So India has an elected head, that is called president, and he or she is elected indirectly for a period of 5 years. So a republic has also two different meaning, also means two more things. One, vesting of political sovereignty in the people and not in a single individual. Like people are electing president, so the original power vests with the people. All right. And the second is the absence of any privileged class, and hence all the public offices being open to every citizen without any discrimination. Everybody can become president. There is no privileged class, like if you are a king, only your son or daughter would be a king. So there is no privileged class. So this is how a republic can be defined. Now we will see another important concept in the preamble called justice. So the term justice in the preamble embraces the three distinct forms: social, economic, and political justice. Three types of justice Indian Constitution talks about, secured through the various provisions of fundamental rights and directive principles of state policy. So in our fundamental rights and also in our directive principle of state policy, we talks about three kind of justice, that is social, economic, and political justice. Now social justice, what is the meaning of social justice? So social justice denotes the equal treatment of all citizens without any social distinction based on caste, color, race, religion, sex, and so on, It means absence of any privileges being extended to any particular section of the society, an improvement in the condition of the backward class like SC, ST, OBC, and women. So whenever there is something we talk about reservation or a particular prerogative right to the SC, ST, and OBC, we actually talks about justice, promotion of justice in a society to those backward classes. So this is called the social justice. There is no privilege to a particular section, and if one section of society is lagging behind, we need to improve the condition of those society through justice, through social justice particularly. Now, economic justice, the second concept of justice is economic justice. So it denotes the non-discrimination between people on the basis of economic factors, elimination of inequalities in wealth, income, and property. So the combination of social justice and economic justice denote what is known as distributive justice. Distributive justice concept of when we talk about the Rawls concept of justice, distributive justice is the base in the John Rawls theory of justice. However, we will not see justice in detail. We will just see justice in preamble of the Indian Constitution. So whenever social justice combines with the economic justice, it is called distributive justice. So we have recently uh, seen social justice, that is absence of privilege to any particular section and the promotion or improvement of the condition of the backward classes called social justice. Economic justice, there is no inequalities in wealth, income, and property. So when we combine these two, it's called distributive justice. So political justice implies that all the citizens should have equal political right. The third concept of justice: first social, second economic, third political. So political justice means that all the citizens should have equal political right, equal access to all political offices, and equal voice in the government. There is no discrimination. All right. So this concept of justice, that is social, economic, and political, has been taken from the Russian Revolution. That is important from examination point of view. Now we will see another important concept, that is called liberty, that is a key word in the preamble of the Indian Constitution. The word liberty means the absence of restraint on the activities of individual. There is no restraint, like you are free to do anything, but it comes with reasonable restriction. It doesn't mean you will kill anyone. That's not liberty. So, and at the same time, providing opportunities for the development of individual personalities. So if you are doing something to improve your personality, so a particular state is providing opportunity for the development, that's called liberty. Like you are free, there is no restraint from the state on your freedom. That's called liberty. So the preamble secures to all citizens of India liberty of thought. You can express your thought, belief. You can have on you can have faith on any ideas. You can follow any religion. You can worship any god through their fundamental rights enforceable in the court of law in case of violation. So in fundamental rights we have freedom of thought, expression, belief, faith, worship, and these rights are enforceable in the court of law. Like whenever there is contravention or violation of these rights, you can go to the Supreme Court or High Court directly and seek the remedy. So liberty, as elaborated in the preamble, is very essential for the successful functioning of the Indian democratic system. However, liberty does not mean license to do what one likes, as I have already discussed recently, that you cannot kill anyone, you cannot do whatever you want, and has to be enjoyed within the limitation mentioned in the Constitution itself. So in brief, we can say that the liberty conceived by the preamble or fundamental rights is not absolute but qualified. So whenever we talk about fundamental right, that we will see in the upcoming videos, fundamental right is not absolute but qualified. It means that there are certain reasonable restrictions are there. It's not absolute. Absolute means you can do whatever you want, but it is not absolute. You can do only that is legitimate according to the constitution. However, there is no clearly definition of legitimation, but some reasonable restrictions are there. Now we will see another concept, but before covering equality, we will see like the idea of liberty, equality and fraternity in our preamble have been taken from the French Revolution. So the famous French Revolution 1789 to 1799 talks about liberty, equality and fraternity. Now equality, the concept equality, what does it mean? So the term equality means the absence of special privileges to any section of society and the provision of adequate opportunities for all individuals without any discrimination. There shall not be any discrimination on the basis of birth, caste, sex, religion, title, etc. And there is absence of special privileges, like we have seen in the case of the presidential election. There is no privilege. Anyone can become president. So the preamble secures to all citizens of India equality of status and opportunity, and the provision embraces three dimensions of equality, that is civic, political and economic. So you have three types of equality in the Indian Constitution, that is civic equality, political equality and economic equality. So the following provisions of the chapter on the fundamental rights ensure the civic equality. So in the fundamental rights, when we see, we will talk about these things, but in brief, these are some of the civic equality that have been granted by the Constitution. First, equality before law, Article 14 it is mentioned. Then in Article 15, prohibition of discrimination on the ground of religion, race, caste, sex or place of birth. Then we have equality of opportunity in the matters of public employment in Article 16, abolition of untouchability, Article 17, and abolition of titles, that is Article 18. So these are the civic equality. There are two provisions in the Constitution that seek to achieve the political equality. The one, no person is to be declared ineligible for inclusion in electoral rolls on the ground of religion, race, caste or sex. In Article 325 we talk about the political equality, that everyone is free to cast their vote and irrespective of their race, caste and sex. And the another one we will see in Article 326. So elections to the Lok Sabha and the state assemblies are to be the basis of adult suffrage, Article 326. So anyone above 18 plus age can cast their vote, and this is also one of the political equality that has been conferred by the Constitution of India. Then the directive principle of state policy, Article 39, secures to men and women equal right to an adequate means of livelihood and equal pay for equal work, because we have seen there are like three types of equality: civic, political, and the third one is economic. So this is called economic equality. That has been mentioned, that is mentioned in Article 39, and it secures to men and women equal right to an adequate means of livelihood and equal pay for equal work. Now we will see the important concept of fraternity. Fraternity, what does fraternity means? It means brotherhood, a sense of brotherhood. So the Constitution also promotes the feeling of fraternity by the system of single citizenship. Indian Constitution offers single citizenship. Unlike the US Constitution that offers dual citizenship, India provides a single citizenship only. Like if you are from Bihar or if you are from Gujarat or Delhi, you don't have separate citizenship. You have just a single citizenship, that is Indian citizenship. So also the fundamental duties, Article 51A say that it shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional or sectional diversities. So fraternity means brotherhood. And when we promote this concept of brotherhood in fundamental duties, we talk about it, and also in the preamble, it has been mentioned to promote the idea of fraternity. So the preamble declares that fraternity has to assure two things. It has to assure two things. The first is the dignity of the individual and the unity and integrity of the nation. So the word integrity has been added to the preamble by the 42nd Constitutional Amendment 1976. According to K. Munshi, a member of drafting committee of the Constituent Assembly, the phrase dignity of the individual signifies that constitution not only ensures material betterment and maintain a democratic setup, but that it also recognizes that the personality of every individual is sacred. So whenever we talk about the dignity of individual, it means that it doesn't mean that only it is for the betterment and maintain a democratic setup for the country. It should be in interest of that personality of the individual too. So every person is unique. They have uh, an unique what we say. Everybody has a unique capacity, ability, and that is sacred by the constitution. So this is highlighted through some of the provisions of the fundamental right and DPSPs, which ensure the dignity of individual. Further, the fundamental duty 51A also talks about the dignity of the women by stating that it shall be the duty of every citizen of India to renounce, means to give up, practices derogatory to the dignity of women, and also makes it the duty of every citizen of India to uphold and protect the sovereignty, unity, integrity of India. So whenever we talk about the dignity in DPSP, it is mentioned in Article 51A, women dignity particularly. Okay. And then the phrase unity and integrity. So unity and integrity is mentioned in Article 1 of the Constitution that describes India as the union of state, and it makes clear that states have no right to secede from the union. So the union government has ultimate right over the state, and it implies the indestructible nature of the Indian Union. That state cannot declare that okay, we are independent, we are going to secede from you. It is not possible in Indian Constitution. So it aims at overcoming the hindrances to the national integration like communalism, regionalism, casteism, linguism, secessionism, and so on. So these concepts have been added only to strengthen the fabric of Indian Constitution and to promote the unity and integrity of the nation. Now we will see the significance of the preamble. The preamble embodies the basic philosophy and fundamental values, political, moral, religious, on which the constitution is based. All right. So we have recently seen each and every terms that have been mentioned in preamble and what is the meaning of those terms. So it contains the grand and noble vision of the Constituent Assembly and reflects the dreams and aspirations of the founding father of the Constitution. In the words of Sir Aladi Krishna Swamy Iyer, a member of Constituent Assembly who played a significant role in making of the Constitution, the preamble to our Constitution expresses what we had thought or dreamed so long. So preamble reflects the ideas that what our forefather, the constitutional maker, had dreamt of for so long. So, according to K. Munshi, a member of the drafting committee of the Constituent Assembly, he said the preamble is the horoscope of our sovereign democratic republic. So, K. Munshi has said that preamble is the horoscope of our sovereign democratic republic. Pandit Thakurdas Bhargav, another member of the Constituent Assembly, summed up the importance of preamble in the following word, and he said that the preamble is the most precious part of the Constitution. It is the soul of the Constitution. It is a key to the Constitution. It is a jewel set in the Constitution, and it is a proper yardstick with which one can measure the worth of the Constitution. Sir Ernest Barker, a distinguished English political scientist, paid a glowing tribute to the political wisdom of the author of the preamble, and he described the preamble as the keynote to the Constitution. He was so much moved by the text of the preamble that he quoted it at the opening of the popular book, Principles of Social and Political Theory. So, preamble contains the principles of social and political theory by Sir Ernest Barker. M. Hidayatullah, former Chief Justice of India, observed preamble resembles the Declaration of Independence of the United States of America, but is more than a declaration. It is the soul of our constitution which lays down the pattern of our political society, and it contains a solemn resolve which nothing but a revolution can alter. So different concepts, different rationality and ideas we can see here from the eminent personalities. Now there is a debate that preamble is a part of constitution or not. So this is one of the controversies about the preamble is as to whether it is a part or not. So we will see the first case, that is the Beru-Berry Union case of 1960. The Supreme Court said that the preamble shows the general purposes behind the several provisions of the Constitution and is thus a key to the minds of the makers of the Constitution. Further, where the terms used in any article are ambiguous or capable of more than one meaning, some assistance at interpretation may be taken from the objectives enshrined in the preamble. Despite this recognition of the significance of the preamble, the Supreme Court specifically opined that preamble is not a part of the Constitution. So to sum up, we can say that in Beru-Berry Union case 1960, it is said by the Supreme Court that preamble is not a part of Constitution. Then we will see what happened in the Keshan and Bharti case. So in the famous Keshan and Bharti case 1973, the Supreme Court rejected the earlier opinion and held that preamble is a part of the Constitution. So that is a change from the previous saying. So it observed that the preamble is of extreme importance and the Constitution should be read and interpreted in the light of the preamble. Then we will see the LIC of India case 1995. So Supreme Court again held that preamble is an integral part of the Constitution. So in Beru-Berry Union case 1960, we saw that preamble is not a part of Constitution. In Keshan and Bharti case 1973, Supreme Court observed that preamble is a part of Constitution. In the LIC case 1995, the Supreme Court again held that the preamble is an integral part of the Constitution. So like any other part of the Constitution, the preamble was also enacted by the Constituent Assembly, but after the rest of the Constitution was already enacted. So it came very lately, saying the reason for inserting the preamble at the end was to ensure that it was in conformity with the Constitution as adopted by the Constituent Assembly. While forwarding the preamble for votes, the President of the Constituent Assembly said, "The question is that preamble stands part of Constitution." The motion was then adopted. Hence, the current opinion held by the Supreme Court that the preamble is a part of Constitution is in consonance with the opinion of the founding father of the Constitution. So this is what the court upheld, the Supreme Court upheld related to the preamble. However, two things should be noted. The first one, that the preamble is neither a source of power to legislature nor a prohibition upon the powers of legislature. Like preamble cannot be a source to give some power or to give authority to the legislature. Okay, legislature can frame their law and preamble is saying something. No, there is a prohibition upon the power of legislature by the preamble. The second concept, we will see it is non-justiciable. We cannot go to the court and seek the remedy whenever there is contravention, so that its provisions are not enforceable in the court of law. Now, amenability of the preamble, we will see whether preamble can be amended or not. So we will see preamble can be amended or not. So question under Article 368, that is amendment of the constitution, arose for the first time in the historic Keshavan Bharti case 1973, because it upheld that preamble is a part of constitution. So it was urged that the preamble cannot be amended as it is not a part of the constitution. The petitioner contended that the amending power in the Article 368 cannot be used to destroy or damage the basic elements or the fundamental features of the constitution which are enshrined in the preamble. Alright, in the Keshavan Bharti case, it is said that whether preamble can be amended or not. So in response, the petitioner contended that the Article 368, which provides the amending power, it cannot be used to destroy or damage the basic element or the fundamental feature of the constitution that enshrined in the preamble, because preamble talks about the key components of the constitution. So the Supreme Court, however, held that preamble is a part of constitution. The court stated that opinion rendered it in the Beruberi Union in this regard was wrong, and held that preamble can be amended subject to condition that the basic features can't be altered. So in other words, we can say that the basic element of the fundamental feature of the constitution as contained in the preamble cannot be altered by an amendment under Article 368. So what we can conclude? We can say that preamble can be amended, but the basic features, the term that is used in the preamble cannot be amended. So the preamble has been amended only once so far in 1976, and we have already seen the word socialist, secular, integrity was inserted to the preamble. Socialist, secular, integrity was amended and it was inserted, and this amendment was to held to be valid because it is said that preamble can be amended. So that is all for today. I hope you liked this topic, and whenever you feel there is doubt, you can ask in the comment. Till then, thanks for watching. Have a great day ahead. Keep studying. Signing off.